Thank you. It's a pleasure to be here, and I'm going to give you a speed tour of the final rule on preventive controls for human foods, because if you've looked at that rule, you've seen it's very large, and we can't possibly cover all of the provisions. Just a bit of background. This rule is called Current Good Manufacturing Practice, Hazard Analysis, and Risk-Based Preventive Controls for Human Food. It's a new Part 117 in Title 21 of the Code of Federal Regulations. We originally proposed this rule in January of 2013. We did a lot of outreach, and we got over 8,000 comments on this rule. And we heard that we didn't get it right in many instances. And we thought about the comments, and we decided that we would make some changes when we go out with an unprecedented approach, and that was to issue a supplemental proposal, which we did in September of 2014. We got more than 1,300 comments on the supplemental proposal. We did a final rule on September 17th of this year, and this final rule considers all of the comments that came in and all of the things that were said in the outreach sessions. And we do want to thank AHPA for the thoughtful and in-depth comments that they submitted on both the original proposal and the supplemental. They were very well done, and they were very informative for us. But just to put this in perspective, the FSMA rulemaking, Food Safety Modernization Act rulemaking, these preventive controls are just the first two. We did preventive controls for human food and preventive controls for animal food. And it's part of a suite of 7 base rules that are coming out on FSMA. And all of these rules work together with to ensure the safety of the food supply. So you will be seeing the produce safety standards coming out, the Foreign Supplier Verification Rule, and third-party accreditation at the end of this month or beginning of next month. And then next spring, there will be intentional adulteration and sanitary food transport. We have made it a high priority to engage stakeholders, and we think that this has resulted in rules that improve food safety and provide the appropriate flexibility to those who have to apply these rules. So what does the Preventive Controls for Human Foods rule do? First, it revises the farm definition. Secondly, it modernizes our longstanding current good manufacturing practice, or cGMP, requirements. Third, it establishes the new FSMA requirements for hazard analysis and risk-based preventive controls. So who's covered by this rule? In general, it's facilities that manufacture, process, pack, or hold food that have to register under Section 415 of the Food, Drug, and Cosmetic Act. This section was created by the Bioterrorism Act of 2002. What it means, though, is that farms don't have to register and retail food establishments don't have to register, and therefore they're not subject to this rule. It does apply to domestic facilities and also to facilities overseas that are exporting food for consumption in the United States. And there are a number of exemptions and modified requirements that apply. These were all directed by Congress in FSMA. First, farm. The farm definition is critical because a farm is exempt from the food facility registration requirements, and facilities that don't have to register with FDA are not subject to the preventive controls requirements. So a lot of people wanted to be farms. Now, depending on certain factors, farms may be subject to the forthcoming produce safety rule. We think that the Preventive Controls for Human Foods rule revises the farm definition to reflect modern farming practices. It was an evolution. We made some changes to the farm definition in the supplemental proposal. We were told by the farming community we still didn't have it right. And so in the final Preventive Controls for Human Food rule, we clarified the definition and we expanded it to cover 2 kinds of farming operations. We call these a primary production farm and a secondary activities farm. The important thing is that both of these are farms with respect to any regulations that apply to farms or don't apply to farms. So that's with respect to registration and other things. First, the primary production farm. This is an operation under one management in one general but not necessarily contiguous location that's devoted to the growing of crops, the harvesting of crops, the raising of animals, or any combination of these activities. This definition has been expanded to include operations that just grow crops and operations that just harvest crops, because we found that there are 2 distinct operations in some cases. And the underlying words reflect some of the changes that we put in place as a result of comments. In addition to these activities of what are normally conducted on a farm and what I, as a city person, normally think of a farm doing, a primary production farm can pack or hold the raw agricultural commodities, or RACs, And that's regardless of who grew or raised them. The original definition of a farm, you had to register if you packed your neighbor's racks. These primary production farms can also manufacture, process, pack, or hold processed foods, so long as all of that food is consumed on that farm or another farm under the same management. Got to be able to feed the farm workers, for example. Or the manufacturing and processing falls into limited categories. These are things like drying produce racks to create a distinct commodity, or drying racks, they don't have to be produce racks, but think of drying grapes to make raisins. That's allowed within the farm definition. Also treating foods to manipulate the ripening, and packaging and labeling of racks. Those are all manufacturing and processing activities, but we say if you do them on a farm to racks, then they're within the farm definition. Now, a secondary activities farm. This is an operation that's not located on the primary production farm that's devoted to the harvesting, packing, or holding of racks. So the primary production farms that grow, harvest, and raise the majority of those racks have to own or jointly own a majority interest in the secondary activities farm. So think of this as what formerly would have been an off-farm packing house, but it's owned by farmers or a farming cooperative as part of their operation. It's just not located where the crops are grown. That is now a secondary activities farm and fits within the farm definition. The definition also allows for certain limited manufacturing and processing, packing, and holding activities. They are the same that a primary production farm can do. There are a number of activities, of course, that are done on farms that don't fall within the farm definition. And this really is any manufacturing and processing other than the limited manufacturing and processing that I've indicated does fall within the farm definition. So, for example, a farmer can dry plums, but he can't pit them. Once he starts pitting them, that's manufacturing and processing. He can chop herbs, that's manufacturing and processing. So these are things that would require this farm to register. Making potato chips, making flour from chickpeas, roasting peanuts, tree nuts, and seeds. Those are all manufacturing and processing activities that require a farm to register. It can be very confusing as to what falls within the farm definition. What's harvesting activity? What's holding activity? What's a packing activity? And then what else is manufacturing and processing? And in particular, because some of these activities fall into more than one category. So we intend to issue guidance on the activities that fall within the farm definition and activities that do not in the near future. Now, so you're not a farm. You're a facility that has to register. There are still some exemptions where you might not have to do the hazard analysis and risk-based preventive controls. This includes activities that are subject to our HACCP regulations, that's seafood and juice, the manufacturing, processing, packing, and holding of dietary supplements, big one for you guys. However, it's for dietary supplements. It does not apply to dietary ingredients. The production of dietary ingredients is either a farm activity or there's manufacturing and processing that takes place on these ingredients that would require that facility to register. Alcoholic beverages are exempt, and activities subject to our low acid chem foods regulations with respect to the microbiological hazards. Certain storage facilities, such as grain elevators or warehouses that only store raw agricultural commodities other than fruits and vegetables for further distribution and processing, are exempt from the requirements to do a hazard analysis and implement risk-based preventive controls. And we expanded the definition of holding to include activities that are performed for the safe or effective storage of racks, such as drying, screening, and fumigating. Farm mixed-type facilities are establishments that are farms, but they also conduct activities outside the farm definition, and they have to register. However, there are certain low-risk manufacturing, processing, packing, and holding activities that are conducted on specific foods by small and very small businesses on farms that are exempt from the requirement to do a hazard analysis and implement risk-based preventive controls. And I would say that the comments submitted by AHPA were very, very useful for us in enhancing our risk assessment that resulted in these food categories and also enhanced the foods that were included in these categories. We have updated our good manufacturing practice regulations. One of the main things we did was to clarify that the provisions that require protection against contamination also require protection against allergen cross-contact. We also deleted certain provisions that were recommendations, things that said you should do this or compliance may be achieved by, because regulations these days only have the mandatory provisions. But some previously non-binding provisions, such as education and training, are now binding. Individuals that manufacture, process, pack, or hold human food have to be trained in food hygiene and food safety as appropriate to their duties. Our cGMPs apply to the manufacturing, processing, packing, and holding of food fairly broadly, but it doesn't apply to farms or activities of farm mixed-type facilities that fall within the farm definition. It also doesn't apply to establishments engaged in holding or transporting of one or more raw agricultural commodities. So you're not a farm, you're not subject to those exemptions. There's one more big exemption I'll come to later. Then you're a facility that has to have a food safety plan. A food safety plan starts with a hazard analysis, and if there are any hazards requiring a preventive control, then the facility has to have preventive controls. They have to have procedures to monitor the preventive controls. They have to have corrective action procedures, verification procedures, and they would also have to have a supply chain program and a recall plan. I'll come back to the supply chain program later. The hazard analysis is the first step in the food safety plan. Hazard identification has to consider the known or reasonably foreseeable biological, chemical, and physical hazards that could occur naturally, be unintentionally introduced, or be intentionally introduced for economic gain. And the hazard evaluation has to consider the severity of the illness or injury if the hazard were to occur, and the probability that the hazard will occur in the absence of preventive controls. Preventive controls are measures required to ensure that hazards are significantly minimized or prevented. They include process controls, food allergen controls, sanitation controls. This is sanitation that applies to the control of hazards. It's not all the sanitation in a facility. Supply chain controls, and a recall plan. The important thing about preventive controls that distinguishes a food safety plan from a HACCP plan is that these preventive controls include controls at critical control points, as in a HACCP plan, but also controls other than those at critical control points that are appropriate for food safety. Preventive controls are not required when a hazard is controlled by another entity later in the distribution chain, but the food has to be accompanied by paperwork that discloses that the food is not processed to control the identified hazard, and the hazard has to be identified there. And the facility that is moving that product along would have to obtain assurances from its customer that the hazard will be controlled. A facility that has implemented preventive controls have to have written procedures, including the frequency that they are to be performed for monitoring the preventive controls, and these have to be documented in records that are subject to verification. A facility has to have written procedures for steps to be taken when a preventive control is not properly implemented. They would have to include procedures as to how the facility would identify and correct a problem, reduce the likelihood the problem will occur again, would evaluate any affected food for safety, and prevent adulterated food from entering into commerce. Verification includes, as appropriate to the facility, the food, and the nature of the preventive control. And if you read the regulation, you'll find these words in many places because they're there to provide flexibility. They would include validation of preventive controls. Generally, these are the process controls. Verification of monitoring and corrective actions. Calibration of process monitoring and verification instruments. Product testing and environmental monitoring as appropriate, and records review. The food safety plan would have to be reanalyzed at least every 3 years, and the plan or part of the plan would have to be reanalyzed whenever there's a significant change that creates the potential for a new hazard or a significant increase in one previously identified, or when there's new information about potential hazards associated with the food, or when a preventive control is found to be ineffective. I want to talk a minute about produce packing houses, because some produce packing houses will fall under the new farm definition, and if they're packing covered produce under the produce safety rule, they would fall under that rule. Other produce packing houses will not fall under the farm definition, and they'll be covered by this preventive controls for human foods rule. However, the specific steps necessary to ensure the safety of produce would generally be the same, regardless of which rule the packing house falls under. The cGMP requirements do apply to the off-farm packing houses, but there are some analogous provisions in the produce safety rule, and we have provided a provision that says that the GMPs can either be those specified in Part 117, or you can follow the applicable requirements in the produce safety standard. We expect all farm packing houses subject to the preventive controls for human foods would look to the produce safety rule in developing food safety plans and establishing what we call preventive control management components, the monitoring, the corrective actions, and the verification. So the food safety plan would focus on a few key preventive controls, generally that have counterparts in the produce safety rules, such as maintaining and monitoring water temperature for produce washing water, and sanitation controls for equipment. And the preventive control management components would be applied as necessary, and we think that product testing for racks would be unlikely, and for environmental monitoring we think that it's also not going to be common, but we do think that some facilities that have wet packing operations may choose to use this as a verification activity. Facilities storing unexposed packaged food are exempt from the requirements for hazard analysis and risk-based preventive controls, but modified requirements for temperature controls would apply if they have any foods that require temperature control for safety. Now, the supply chain program. This is, I think, a very confusing area. It's so extensive that we gave it its own subpart in Part 117. And the reason it's so extensive is people ask for flexibility. And in order for us to write in that flexibility, we had to write a lot of language. First thing to point out is that the supply chain program provisions apply to a manufacturing and processing facility. And they would have to have a risk-based supply chain program to ensure control of hazards in raw materials or other ingredients when the control is applied before receipt. So if the manufacturer processor is going to apply the control, then he doesn't have to ensure that someone else before him has applied the control. We call this a supply chain applied control. Remember, it applies to manufacturers and processors, so it's not distribution centers, it's not packing houses. Also, the definition of supplier. It may not be the common understanding of supplier, which usually is who you buy something from. A supplier is the establishment that manufactures or processes the food, raises the animal, or grows the food that's provided to a receiving facility, which is a manufacturer or processor, without further manufacturing or processing by another establishment. So, a supply chain program for someone who has to implement it because the hazard is controlled in the raw material or ingredient they're receiving. It requires the use of approved suppliers. It requires the facility to determine appropriate supplier verification activities and to conduct and document these supplier verification activities. However, flexibility is provided for someone else in the distribution chain to do the verification activities. So a distributor could do that and provide that information to the person he's selling it to. When applicable, the facility has to verify a supply chain applied control that's applied by an entity other than the facility supplier or obtain documentation of verification by another entity. Supplier verification activities include on-site audits, sampling and testing, a review of the relevant food safety records, or there may be some other verification activities that are appropriate. And we provided flexibility for people to include something other than what we've listed here. The activity and the frequency of these activities are based on the nature of the hazard, where it's controlled, and supplier performance. Does the supplier have a warning letter or an import alert against him? Have you been using the supplier for a long period of time? You have information that the supplier is always in compliance with your requirements, then the verification activities might be different. We have modified supplier verification requirements for certain suppliers. I think of those as the small guys, and I won't go into that. I want to talk briefly about qualified facilities. Qualified facilities were provided for in FSMA, and essentially, very small business would be a qualified facility. This business would be exempt from the requirements for hazard analysis and risk-based preventive controls. They do have some modified requirements. They are still subject to the cGMPs. They are still subject to our inspection frequency. They can't produce unsafe food. We define a very small business as one that averages, and that's a 3-year average, less than $1 million per year in sales of human food, plus the market value of human food manufactured, processed, packed, or held without sale. That may be a little confusing, but this is to provide for warehouses that only hold foods to be small business, very small businesses, and get the exemption as a qualified facility. The modified requirements they would be subject to are simply attestations. They would have to attest that they are a qualified facility, they meet the definition, and then do one of 2 other attestations. Attest that hazards have been identified, preventive controls have been implemented and they're being monitored, or that the facility is in compliance with an applicable non-federal food safety law. Compliance dates. There's a 60-day effective date for the rule, but we've put staggered compliance dates in for businesses. The very small businesses, which just have the modified requirements, have 3 years to comply. A small business, which is a business with fewer than 500 full-time equivalent employees, has 2 years to comply, and then all other businesses, except for those under the pasteurized milk ordinance, have 1 year to comply. Separate compliance dates have been established for the supply chain provisions to accommodate the compliance dates for suppliers of different sizes and those subject to different rules, such as the Produce Safety Standards and the Foreign Supplier Verification Program. Implementation is not going to happen overnight. We're starting a long process here. We are committed to educate before and while we regulate, to devote resources to training, to education, to providing guidance documents. We have a number of guidance documents in the works. I mentioned the one about the guidance on what activities fall within the farm definition and which do not. We also have some general guidance on hazards that apply to specific food types. We have guidance on environmental monitoring, on allergen controls, and there will be supply chain guidance. We've also established the FSMA Technical Assistance Network at FDA. This is very important because this is the group that is going to answer questions for industry and for our regulators as well. We are establishing an infrastructure for industry and regulator training. We are working with alliances, specifically Food Safety Preventive Controls Alliance for the Preventive Controls Rule, which has developed a standardized curriculum that will be used both for training industry and for training regulators, federal and state. And we are partnering with the states because we know that we can't do this alone. We're going to have other people helping us with enforcement here. This is probably the most important slide in the whole slide deck. And this has the URL for our website. A subscription feature is available, so you can get emails when updates occur on the site. The important thing is you can contact FDA with your questions about FSMA through a new online form. There's a big URL here, but if you go to the FSMA webpage, you go down the bottom, contact us. It will lead you to the form where you can ask questions. I urge anyone who's asking a question to be very specific about the situation you are asking about. We've gotten some that are so general, it's like, well, we don't know how to answer it. There's if this, then that, and we just can't go through all the scenarios. So the more specific you are, the more specific an answer we can tailor to your question. These questions go to experts within the center, they get legal vetting, and then an email goes back. We'll use it for developing Q's and A's that will be posted on the website, and it'll go into our knowledge management system for future questions that come through. And with that, I guess I can take some questions.
Jenny, thank you. Jenny Scott. Questions? We have time for a few questions. Anybody? Did I see a hand there?
There's one over there.
Yes,
Sheldon.
no?
Left, far left.
Oh, right there. Okay.
Well, I apologize in advance if I misunderstood, but I'm still a little bit hazy as to exactly how this applies to dietary ingredient suppliers who are supplying to the dietary supplement industry.
So the question is how this applies to dietary ingredients. If the dietary ingredients undergo any kind of manufacturing and processing before they go to the dietary supplement manufacturer, then those are activities that would fall under the preventive controls rule. They'd have to do the hazard analysis to decide what, if any, preventive controls need to be applied. Now, keep in mind that we have said in the preamble that there may be operations that will do a hazard analysis and determine that there are no hazards requiring a preventive control, and that is acceptable to us, but there has to be justification for that. We think that most activities doing some sort of manufacturing and processing will likely have a preventive control, but it could very well be that the GMPs are sufficient.
And then there was, at another session I was at recently, there was a little bit of confusion about exactly what the terms receiving facility means. So there was a question raised in that session about if you were a dietary ingredient manufacturer and you're receiving ingredients into your facility, are you the receiving facility responsible for the controls on those, or would it be your supplier overseas who might be receiving raw materials and doing a manufacturing process like extraction, powdering, something like that, and then shipping it to you?
Well, if you are a dietary supplement manufacturer and you are receiving in dietary ingredients, you would be a receiving facility if you were subject to the rule, but you're not subject to the rule. So the receiving facility is defined in the rule as a manufacturer or processor, but again, it still has to be someone who is subject to the provisions of the rule before you would be considered a receiving facility.
Thanks.
Now, the provisions of the Foreign Supplier Verification will be coming out at a later date, hopefully very soon here, and we'll see how this all works together, because there will be some additional requirements for the incoming materials from the importers.
Hold on here.
Good morning. I have a question in regards to whether the dietary supplement companies can control for some of the risks down the line if they're willing to, because one of the assumptions is that if the next person in the supply chain can control for the hazard analysis or the hazard risks, that we may not have to do it previously.
Well, that's an interesting question, but those provisions apply to someone who's subject to the Preventive Controls for Human Foods rule, which is not a dietary supplement manufacturer. So now it could very well apply with respect to a dietary ingredient manufacturer or processor, and this would be a good question if you have a specific example of exactly what activities go on in which facility, and you can submit that to the Technical Assistance Network. That would help us think through this and give you an answer.
Let's take two more.
Good morning. My name is Nora Dowell from International Vitamin Corporation. My question is for the raw material suppliers that are brokers. Mm-hmm. So as we know, in the dietary supplement industry, a number of our suppliers are brokers. Mm-hmm. What is their level of responsibilities? And how would they comply with FSMA?
Well, a broker, if it's just a straight broker, is not, well, we'll have to think through this. Do they actually, it really depends on whether that broker takes possession of the food as to whether they're holding the food, in which case they would be subject to registration. So this all goes back to, do they have to register? So if this is a broker that has the food and has to register and is selling to further customers, remember that if there is a control that's been applied on that material that he's selling, then someone has to do supplier verification. And it may be that the broker wants to ensure that the supplier verification has been done so he can provide that information to his customers.
So can we expect to require all these brokers to supply us, the dietary supplement manufacturers, with the verification program from all their manufacturers?
This gets a little complicated because, again, the dietary supplement manufacturer is not subject to the rule. So, therefore, the dietary supplement manufacturer does not have to implement the supply chain controls. So it may not be applicable in this situation.
But we will still be requiring our suppliers to comply with FSMA.
FSMA is a very broad term. There are a lot of regulations that come under FSMA. So if you're talking about requiring them to
So I would say with product control, to be specific, with product control for human foods.
Okay. So, again, these are the types of questions that if you provide us a detailed scenario, then we can analyze it and get back to you. So I would encourage you to use that technical assistance form.
We'll take one more.
Even though dietary supplement companies are not subject to these rules, is there going to be some level of documentation requirement to make sure that what we're bringing in, how is this going to tie into our requirements to qualify our ingredients that come in? What kind of documentation? And maybe I'm getting a little ahead with Kara's presentation, but there seems to be some need, will there be some need for us to prove that our suppliers are compliant?
Well, a dietary supplement manufacturer is subject to the dietary supplement GMPs, and as long as they're in compliance with those MPs, they are not subject to the preventive controls rule. So there should not be any additional provisions that fall upon the dietary supplement manufacturer as a result of the preventive controls rule. But again, it's a good question. I would submit it through the Technical Assistance Network with some specifics.
Specifically on qualifying your suppliers, what documentation, level of documentation will be required would be the
I'm going to have to leave that to Kara as to what the dietary supplement requirements are for that, because you don't have those requirements under the preventive controls rule because dietary supplement manufacturers are not subject to the rule.
Yeah, let me ask a question. And although first comment, I really do appreciate your acknowledgement. AHPA filed over 400 pages of comments to the various rules, 5 of the 7 rules. And we do see many of the comments that we made now expressed here, and that's deeply appreciated. The one in particular, over and over, we said you can't require a kill step at every stage. You can't require treatment of the hazard at the farm, and then at the co-op, and then at the packing house, and then at the manufacturer. You've got a completely denatured product there. It appears as if you heard that. Yep. And Stacy Eisner was the primary author, though she couldn't be here, so I'm texting her, and I told her preventive controls not required if your customer will address the hazard. That's what we propose. Her response is, whoop, whoop, that's huge. So really appreciate it. And then I do have a question, and more in the produce safety rule, but they're all connected. This current event of cucumbers and salmonella, over 700 cases reported in 35 states, 4 deaths. In our best hope of a fully implemented produce safety rule, would that have been prevented? Would that have been stopped? Or are we still going to encounter those kinds of things, even with the systems all in place?
We're certainly hoping that the produce safety rule would have an impact on that. Right now, we don't know what the cause was, what the root cause, so we can't say for sure, but we would anticipate that, yes, it would prevent this.
Great. Okay. I think, and we would hope that it would.
Yes.
It's the biggest change to the Food, Drug, and Cosmetic Act ever, and so we sure hope it has that level of impact.
Okay. Thank
Jenny
you very
Scott,
much.
thank you very
Thank you
much.
very much, Jenny.